Good evening, everyone. I'm a legal intern in LEXIS and Company. So today my video presentation topic is inter-country adoption before CARA. So inter-country adoption means the adoption of a child from a different country and legally binding ourselves to be her parent. In simple words, it means the adoption of a child by two individuals together known as husband wife or a single individual who legally bind themselves as the parent of an adoptive child. There were no provisions in the law for inter-country adoption. CARA also came very late, so the framework and the guidelines regarding inter-country adoption were originally given by the Supreme Court through cases. So, referring to the Lakshmikant versus Union of India, AIR 1984, the Supreme Court laid down the normatives and the procedural safeguards regarding foreign inter-country adoption. This case arose out of a letter written by the lawyer of the Supreme Court, which was treated as a petition. The letter was based on the report published by the Mail from the London, which revealed that hundreds of unwanted babies were being transported from the shimmy of Calcutta to the USA. These were done by the organization and private individual. These malpractices were done in the name of adoption, and the child was sent to foreign country. The adoptive parents' negligence led to the harassment of the child. The Supreme Court observed that in the absence of law in inter-country adoption, the child is at the risk as enormous risk and risk of at enormous risk and risk of trafficking. In this concern, the Supreme Court, with other children welfare organization, gave direction and guidelines in the process in processing adoption to foreign parents under the Guardian and Ward Act 1840. The delineated safeguards include, among several others, the requirement that foreigners wishing to adopt be sponsored by relevant licensed agencies in their own country, that no adoption and licensed by the Government of India must meet no adoption application from a foreign should be entertained directly by an adoption agency in India. The agency working on inter-country adoption and licensed by the Government of India must meet certain stipulated criteria and undertake special responsibilities in ensuring the safety and well-being of adoptive children, and that all the inter-country adoption procedure must be approved by the local courts. In the matter of Inri Rashikalal Changalal Mehta AIR 1882, the court held that inter-country adoption under Section 9, Clause 4 of the H.A.and.M. Act 1956 should be legally valid under the law of both the countries, and the adoptive parent must fulfill the requirement of the law of adoption in their countries as well as the country of adoption. It is essential to fulfill the adoption requirement in both the countries. It is necessary to ensure that the child will live a better life in a satisfactory condition, so the social inspection of the parents is also necessary. So we can conclude by saying that before CARA, it was very hard for the process of adoption. There were many malpractices in the name of adoption, and the children were exposed to sexual harassment, harms, assaults, and all. So only we were supposed to go through the judge-made laws, and but after CARA helped a lot of them by giving the strict rules for the protection of the children.